All rise. Court of Appeals, Division 1 is now in session.
Thank you. You may be seated. We're here this morning on our case number 1CA-CV 160728, Allen versus Town of Prescott Valley. Counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal, but if you do decide to reserve time, you're in charge of keeping track of it. The clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you if you would give us your name and the name of your client when you approach the podium, both the first time around and the second, if that's what happens. We've read the briefs and we've looked at the record on summary judgment. We've also discussed the case in our conference this morning. So with that, you may proceed.
Thank you, Your Honor. May it please the court. Good morning, Your Honors. My name is Mark Kelly, and myself and my co-counsel, David Abney, are here on behalf of the plaintiff appellants, Jared and Jade Allen. And we are here this morning to examine a primary issue of whether or not a admission fee of $270 should be considered nominal. In summary, the trial court erred in finding that Jared Allen was a recreational user because the $270 team fee that he paid was nominal, and therefore, pursuant to ARS Title 33-1551-5, the nominal fee was not considered as an admission fee, and he was found to be a recreational user. Arizona's recreational user statute is 33-1551, and this statute is capable of creating qualified immunity for a municipality if a recreational user is found. In 1998, the legislature amended the statute and added the word nominal to it, which creates higher potential for qualified immunity. To this date, no Arizona court has determined what nominal means, and that's what we're here to talk about today. The case of Prince v. City of Apache Junction did address the recreational user statute, and what we should pull out of the Prince case, which we feel is highly applicable to this case, is that a softball team fee of $250, which was an admission fee, was found to exclude the recreational user statute. The individual who was injured on a fence at a softball game was therefore allowed to proceed forward, and the court also determined it didn't matter who paid the fee of $250. And when you look at the Prince case, there wasn't any determination of each player being parceled out a piece of the $250 to determine who paid the fee.
What do you make of the fact, though, that the legislature added the reference to nominal after Prince?
The legislature subsequently added nominal after the Prince case to determine to effectively provide additional artillery for any future public entity. You
don't think to express their disagreement with Prince?
I'm sorry?
You don't think it suggests that they disagreed with the result in Prince, and that, in their view, $270 might have been a nominal fee, or that $250, whatever the amount was?
I don't, Judge Catani. I feel that the nominal language was added in that it was part of many other recreational use statutes, but if they were really trying to dissuade or push cases out of litigation similar to Prince, there would have been a definition of nominal added into the statute.
What's the flaw in the logic, though, that it's you allocate it per person. I mean, if the notion is that if it's the number of people using, what's the difference between charging a per person fee and a larger fee for a big group? Why can't we just allocate that to each person? What's the difference in saying a family rate of $10 or an individual rate of $2? Why is there that much of a difference between that approach?
Well, to this date, we don't have any precedent that has done that.
What's the flaw in that logic of just saying, yeah, this $270 should be apportioned among the number of people who are using
The flaw in the logic is that it's a moving target. You have 8 games, you have so many players, and so many players may not be playing all 8 games. So the calculations that the town has used take into consideration that all 12 players played all 8 games, and therefore we arrive at $2.81.
What, in your view, where would it stop being a nominal, or what would be a nominal fee? I guess is the question for you. So in your view, 270 is not. At what level is it? Does it have to bear some relation to the upkeep of the facility, or does it have any relation to whether the landowner is generating a profit, or what kind of standard would you suggest?
Well, the McKinney case held that in order to find a fee nominal, you have to consider 2 factors. And those 2 factors are, number one, that it is nominal. And so that's, I believe, Judge Catani, the question that you're asking me. But number 2, that it also pay for the services that are provided. Here in this case, the services that were provided were lights. And ironically, one of the services that Jared Allen was paying for, in addition to reserving the field, in addition to making sure there was a game that night, were lights, and those lights were not functioning. And so,
Do you also cover the cost of the umpire?
To my knowledge, it does. Yes.
So how much is left over after paying an umpire? It doesn't seem like there's a lot to maintain the property.
Well, to get back to your question, Judge Catani, to be considered nominal, the fee would have to be below what the value of the service is. And when you collectively look at what the fees that all the teams are paying, which are $270, and if you presume that all teams have 10 to 12 players on each team, and you arrive at $2.81, well, that's the value of playing softball, is $2.81 each player. So even if you use that logic that the town is wanting to use that's not contained in the statute, you still find that $2.81 is not nominal because that is the value of playing softball. A nominal fee would have to be well below that amount. A nominal fee is trifling.
How would you suggest? Sorry, go ahead.
I'm not sure you can value softball.
Well, yeah, wouldn't you to play softball? You'd have to presumably you'd have to have some land, someplace to play. Hard to just get together with 18 people and say, or 20, however many you're going to play, and say, with $2 we can have a league. You've got to have someplace to play. So that seems pretty nominal.
Or what if the city had a multi-use facility with a lot of softball fields and set up a gate at the beginning, at the entrance, saying, anyone who comes in with a jersey, you need to pay $3 to get in. Would that be a nominal admission fee?
If the game or the fields were reserved for $3 per player?
Anyone who came in needed to pay $3.
Well, if you look at McKinney, that would not be a nominal fee because McKinney says that a fee that ensures you the use of a field, ensures you the use of the resources there, ensures your right to be on that field is an admission fee. And to be nominal, which has not been decided by the courts yet, the McKinney court did provide some definition by using dictionary definitions. And when you look at the dictionary definitions, which we include on page 17 of our brief, those definitions are a trifling amount, an insignificant sum. What I think of a nominal is when a family member is essentially giving a house to another family member, but you have to have a trade of consideration. So there's that $10, for the sum of $10 you get this house, or the same thing for a car. For the sum of $10 you get a car. Generally, cars are worth exceedingly more than $10.
So you think, in answer to Judge Johnson's question, that $3 per person, if it's just a $3 admission fee, and they call it an admission fee, because they call it an admission fee, that $3 can't be nominal?
Yes.
What if it was $1?
If $1 is what the town decided that would cover the resources that were available.
No, it's not. It's not. Obviously, $1 is not going to cover it, but it'll pay for a lawnmower here or there.
I don't think $1 would be a nominal fee as well.
50 cents.
When we're looking at, we have to look at the whole scope of what is provided. What are you getting? And if the going rate for playing softball is $270 for the town of Prescott Valley in October of 2014, then that's the value of what you are getting. That's the value of getting a field for the night, competition, umpires, lights.
So you're saying, okay, you're saying that what nominal means with respect to the value that you're getting. You're paying much less than the value. Where do we get that? What teaches us that that's how we define nominal?
Candidly, I think that's up to the legislature, Your Honor, to put that into the.
But I mean, where do we? If we're going to write that in a decision, what do we cite for that proposition? As opposed to, I mean, another way of looking at nominal is it's not very much in the abstract. So how do we decide? What do we look to in deciding whether it's the former or the latter definition?
I think you need to look at, like the McKinney case provides. It's a fact-specific question. You have to look at the resources of those who are coming into play. And you can't compare those resources to the resources of a town. The town spends $32,000 for a water bill. Well, that's to irrigate the whole entire park, which is massive, not just those 4 softball fields. You have to, it's a fact-specific question. I think it depends.
Value, if it's fact-specific, can you point to the information in the record that you provided for the value? For example, how much it would have cost the team to rent a field and pay an umpire, field with lights, all of these amenities, 8 times over the course of this type of season?
Judge Perkins, and those are the facts that we don't have yet in this case. Those are the facts that if the defendant wanted to attempt to show the jury that it was a nominal fee, we would have to collect all those facts as the McKinney case states. It's a fact-specific question that should be decided by the jury. What is nominal? Is $2.81, is $270 nominal? Again, the statute doesn't determine a breakdown as they have conveniently done. Should we break that down even further to the innings? Because not every player plays an entire game. They might only play 3 innings or 5 innings.
So you envision that if the court were to reverse into a summary judgment, whether the statute applies would be a jury question, effectively?
It is a jury question, Your Honor, to decide what the meaning of nominal is.
What do we have for that proposition?
We don't. What do we have? I'm sorry, Your Honor.
Yeah.
I don't.
What as opposed to the court simply? I mean, the court is going to have to instruct the jury. And so, are you suggesting that the court would first instruct the jury to determine whether the fee was nominal, and then depending on how it finds it goes on that question, it then would decide. It then would assess the conduct on either a negligence or a gross negligence standard?
Yes, because if it is found to be nominal, then he is found to be a recreational user, and then that triggers the gross negligence aspect, which gross negligence, coincidentally, is provided as a definition in the statute. And coincidentally, that's another issue in this case.
We want to give you a chance to talk about that, too. What is your best case for the proposition that what happened here can be construed to be gross negligence?
Well, gross negligence, defined by the statute 33-1551, is a knowing or reckless indifference to the health and safety of others. We have evidence that the town had knowledge that the lights were out. We have evidence that the installer of the lights knew that the lights were out. We have evidence that other team members saw that the lights were out. We have evidence that the team members saw dark spots on the field. We have evidence that the town of Prescott Valley uses the ASA rules and could have called the game. And we have evidence that the umpire did not call the game and went ahead and pushed the players out into the field in a dangerous condition.
Is there another case that we can look to that would, with facts that are similar or anywhere like this, where we can say, yeah, that was grossly negligent?
When you look at the statute that's provided, a knowing or reckless indifference to the health and safety of others, I think that's what we look at. This statute actually provided its own definition of gross negligence. In the past year or so, there has been some decisions that have been coming out. Gross negligence seems to be kind of a moving target presently in litigation. In this case, I think the statute that is provided is what prevails. And that's a knowing or reckless indifference.
Is there any negligence apart from the umpire not calling the game? And admittedly, that may be a very significant aspect, but you're not suggesting the city should have acted quicker. There's some obligation to fix lights within 2 days or whatever, however long the lights had been out. Is there something else? Is the gross negligence that you're asserting simply that the umpire who's hired by the city had an obligation to call off the game?
Yeah, so by not calling off the game, that was a knowing or reckless indifference to the health and safety of others. By not repairing the lights before the game, that was a knowing or reckless indifference to the health of others.
There's an obligation to go in and repair lights at a softball field, maybe take priority over other city obligations. It doesn't seem like this was a long period of time.
They could have called the game then. It's just an easy fix.
But that's the negligence that you're asserting is the umpire should have called the game.
Yes, as has happened numerous times throughout history. I'm going to reserve the rest of my time for rebuttal.
Thank you.
Thank you, Your Honors.
Good morning. William Doyle with Brian Hauser on behalf of the town of Prescott Valley. Stephen Zarek, the city attorney, town attorney, is also here. Good morning. May it please the court. I don't want to get bogged down in the gross negligence, but since that was addressed at the very end of plaintiff's argument, let me just say that gross negligence was never alleged. There is no allegation of gross negligence in this case. And the court should keep in mind that gross negligence is on a clear and convincing standard. And so the idea that there is some conduct here which would rise to the level of creating a jury question as to that issue is simply not the case.
Is clear and convincing in the statute?
It is not in the statute, but
then why does that?
Well, because the Supreme Court has ruled on more than one occasion that gross negligence, and which gives rise to a punitive damage claim, is held to a clear and convincing standard, and it's the town's position that that would apply to the allegation of gross negligence under the statute.
Is there a case that supports that?
Not that I'm aware of, Your Honor.
Okay.
Not that I'm aware of.
Okay. Is there? What would you point us to in terms of a case authority that would help us assess whether anything here could be grossly negligent?
Well, I don't think there is one, because I think it's factually specific as to what the allegations are. I mean, that was the whole point of, you file a motion for summary judgment. The allegation of negligence has been made. There has been no allegation of gross negligence. The town's immune. Well, then the motion's granted. Let's assume there was a gross negligence allegation contained in the complaint or in the disclosure statements. The court has the ability to look as to whether there is a factual dispute which could be allowed to go to the jury. There was nothing here presented which raised a factual issue. So, no, there's no case out there that's going to say Under these facts, that's not a gross negligence standard, but it is a gatekeeper function of the trial court that there's not a reasonable factual issue, and in our position is there isn't one here.
What's the authority for the proposition that in a case like this, in a negligence claim, where the affirmative defense is the town has a qualified immunity that, if it applies, would require you to prove your claim, prove gross negligence? What's the case for the proposition that the complaint in the beginning needed to allege gross negligence rather than just mere negligence?
Because under the statute, in the absence of immunity, the only obligation of the city can be in response to gross negligence. You don't, and it's a notice pleading state, obviously, and if you don't allege gross negligence, the defense is presented in the answer, and there is a subsequent disclosure statement which doesn't raise gross negligence. It's the simple obligation that there's no notice and no allegation of that. How is the city supposed to respond to an allegation that's not been made?
Well, I think the argument would be that the city raised the issue in its answer, and then if the statute applies, then we'll see what the facts are.
Right. The city did raise it in its answer, and the plaintiff's given an opportunity to make an allegation which avoids the defense raised in the statute.
Make an allegation in what context?
It raised an allegation of gross negligence.
But why is that much different than the allegation of negligence? They're suggesting the allegations, they've alleged that the umpire should have called the game,
Right.
that's
And they allege
negligent.
that. Excuse me.
They've alleged other things, but why can't we construe that as an allegation of it? This is very bad negligence. This is gross negligence. Do you have to actually put in, this is not only negligent, it's grossly negligent?
Yes.
In what?
The answer to your question is yes, you do.
In what pleading?
First, in the complaint, because one is on notice of the existence of the recreational use statute, but secondarily, once the defense has been raised, the plaintiff has an obligation either to amend their complaint to add gross negligence or at least, at a minimum, include it in their disclosure statement to raise the issue in response to the defense that's been raised.
Is there a case that says that the plaintiff needs to amend its complaint to meet an affirmative defense in the answer?
Well, not that I have off the top of my head, all right, but I am quite sure, Your Honor, that there are cases that relate to amending pleadings to assert causes of action, and a gross negligence is a cause of action which should be pled. It's conduct against the city which was not pled, and the city was therefore not on notice. So how is the city supposed to respond to that in relation to at the time of summary judgment hearing?
Did the city do any different? Do anything, has the city been prejudiced at all by the failure to amend the complaint or the failure to say in a disclosure statement that the acts were grossly negligent as opposed to mere negligence?
Absolutely.
How is the city been prejudiced?
The city didn't have the opportunity to conduct additional discovery on what exactly happened at the time of the baseball game, didn't have an opportunity to investigate or present affidavit.
Didn't the city move for summary judgment?
Sure.
Well, why couldn't it just wait and conduct discovery
Because there was
first?
no allegation of gross negligence. Why should the city wait? The city moved on the recreational use statute. If we had known gross negligence was going to be raised at the time of the hearing or alleged by the plaintiff, the city would have been in a position to add additional factual information, additional affidavits from the umpire, from the maintenance people, for example, to provide a basis for the court to rule as a matter of law that there was not a factual issue on gross negligence. So, yes, the city was prejudiced. Let me talk about the statute for a moment, if I can. The court needs to keep in mind that the underlying purpose of the statute is to encourage landowners to make their land available for the recreational use of the public. All right? So, and any determination as to what the language means needs to be made in that context. So, the idea that this statute was amended, as the plaintiff claims, after Prince, is really minimizing the impact. The legislative history of the 1998 amendment clearly shows that the amendment is in response to Prince, Prince versus City of Tucson. And the reason that's important is because the legislature, in identifying the word nominal attempts to make and does make a distinction between nominal and admission fee. And it doesn't just say nominal, it says nominal in a nominal fee that is charged by a public entity or a nonprofit corporation to offset the cost of providing the educational and recreational use. So there's a purpose to the nominal issue. And so we believe that in the context of a softball team and the one particular plaintiff, then you have to evaluate whether or not the fee to this particular person is nominal in relation to the cost associated with providing the recreational facility, i.e. the underlying purpose of the statute. And so it's perfectly appropriate to break the fee down to what ends up being $2.81, because that is the amount that this particular plaintiff is paying to utilize these facilities. And so, and there are all sorts of costs associated with it. There is the $32,000 in irrigation expenses. There isn't just the lights and the umpire. There's maintenance, there's equipment, there's a whole variety of expenses.
At what point would you, in your view, would it cease to be nominal? It seems like you could get to a point where you're paying a pretty non-nominal fee, but still not paying enough to where the city would be generating a profit from the activity. Are you saying that it has to generate a profit, reach that level? It can be somewhere in between?
I'm suggesting it can be somewhere in between, and I am suggesting that the definition that the court would have to adopt is one that both recognizes the element of cost, but also recognizes the element of encouraging the public to use the land. So, sure, if the city came in and said, on an annual basis, it costs us $100,000 to maintain Mountain View Park or Mountain Valley Park. And so $270 in relation to that, here's how many people potentially use it. And so all the city's doing is breaking even, all right? And let's say the price was $500. All the city's doing is breaking even, so it's a nominal fee. Well, the city doesn't take that position, because we recognize that the underlying purpose of the statute is to encourage use of the property, and at $500, even if it is a break-even number, that may discourage use of the property as opposed to encouraging it.
When you say use, you mean used by the owner or used by the person who's coming on?
Used by the public, right?
Okay.
Purpose. That's the underlying
What if it were $270 per person? Would that, in your mind, take it out of the nominal fee range?
Yes. But again, I think that's an evaluation that the court needs to make. I mean, that there are no facts disputes here. You have to make a determination whether that's nominal. But
I'm just curious. Is there a point? $100 per player? Is
you
that?
know, I think the problem is that the plaintiff wants the court to evaluate the concept of nominal from the perspective of the user, right? So $100 might be well in excess of nominal to a 10-year-old Little League team, okay? It might not be nominal to me, for example. But the fact of the matter is that the statute suggests, and we would argue requires, based upon the 1998 amendment, that the evaluation of what nominal is from the perspective of the landowner, because it is the purpose of the statute to encourage.
But under that analysis, anything's nominal. If it really costs $5 million to maintain the property, anything less than that's a pretty nominal. I mean, the per person fee is pretty nominal, and you've suggested that 270 would not be nominal. So it seems to me the easier way the more logical way to analyze it is from the perspective of the user, whether it's a nominal fee.
Well, what if? I get that. That's what they're proposing to you. But then there has to be a factual evaluation of each individual plaintiff. So the landowner has no way of putting themselves in a position to avail the benefits of the statute, because it doesn't know the economic situation of the people who are going to be using the park. So the town has to be the town has to make an evaluation that if the people who are going to use the park are unemployed, for example, well, then the amount they're charging isn't nominal to them. Well, that ruins the purpose of the statute.
Well, but that would ruin the, but perhaps there's a medium ground, which is nominal to vis-a-vis what the user is getting, and not nominal vis-a-vis whether the user can afford it. So it only costs a couple bucks to come in.
And you're getting the use of an umpire, you're getting use of lights on a field.
I don't disagree with the court. What I'm suggesting to you is that the definition needs to encompass both the concept of nominal as it relates to the general public, generally, but also to encourage the landowners to make the property available. And so I can't tell you, is it $270? No. Is it $100? No. Is it $33? Which, so all 12 players don't show up for every game, but there's 8 games and
Yeah.
$270 is $33. Is that nominal? Again, it's the definition is. I'm sorry, Your Honor. Go ahead.
I was just going to say, do you when you look at it from the perspective of the landowner, do you think then it really is you look to see what's the upkeep cost versus what are the fees collected? Does that bear on whether it's nominal?
Marginally, yes. All right.
I see what you did there.
Marginally, yes. But it is more a function of encouraging the landowner to use it. So the landowner certainly has a right to obtain some reimbursement for the costs right, but that reimbursement has to be in the concept of nominal. And I get nominal's not a, there's no specific definition out there. Yes, is it token? Does it represent the value? That's the point of suggesting that the court needs to provide a definition.
Now, can it be a jury question, as the appellant is arguing?
No, because what would the court instruct the jury? I mean, I appreciated the court asking the plaintiff those questions, but there is no factual dispute here. We know what they paid. We know what they were using. We know how many were there. We know how many times they were there. And Prince tells us that it is a determination, although Prince uses the word fact determination, it is a fact determination for the court to make as to whether it constitutes nominal under the Prince opinion. And so let's assume you reverse it and send it back to the trial court to let the jury decide what's nominal. What instruction would you give the trial court on how to instruct the jury on the term nominal? Well, you would provide them a definition of nominal, which then allows the court to determine whether this fee was nominal or not.
Do we instruct the jury on the elements of other sorts of qualified immunities?
I'm not sure I understand the court's question.
I'm trying to think of other qualified immunity statutes, and the only ones I can think of deal with public servants. And so it's not really a question whether the defendant is a deputy sheriff, for example. But perhaps it could be a question about whether he's acting within the scope of his authority in order to come within the.
Right, I understand. I understand. I suppose on a theoretical level, yes. Would it be conceivably possible for the court to send it back and have it tried and have a jury determine whether it's nominal, and then the court make a legal decision post that determination as to whether the immunity applies? As you suggest, in the concept of a law enforcement officer, whether he's acting as a law enforcement officer or as a private citizen, and the jury makes that determination. Fine, but under those circumstances, there is law and case law which allows the court to instruct what course and scope is.
Right, right.
Again, back to my original point, there's no. What would the court instruct the jury here? And so I think on this record, the court can craft a definition of nominal, which it has declined to do so far. I get that. Prince Court did, and subsequently the McKinney Court, I guess it's only the McKinney Court, because that was after the 1998 amendment. But, it can craft a definition which allows it to rule under this factual scenario. Anything else? I'm good. Thank you.
Thanks.
Thank you, Your Honors.
Could you address the argument that there's never been an allegation of gross negligence? And what's your best authority for there not being a requirement that the plaintiff pleaded at some point or amend the complaint to allege gross negligence?
Gross negligence is not a cause of action, Your Honor. It's a variety of negligence. We have pled negligence from the get-go. Our complaint asserted that the town of Prescott Valley was negligent. That's all you have to prove when you're not a recreational user. From the get-go, the plaintiffs have asserted that they paid the admission fee, and that when you pay an admission fee, you're not a recreational user, and therefore you're only...
Their argument is you're on notice that that you might be held to be a recreational user. Is there an obligation? Do you have any authority, or is there any case law out there that would help us in assessing whether there's also a requirement that you alternatively plead, assuming we're a recreational user, the city was there was gross negligence?
I think the evidence can conform to the pleadings. Thus far in this case, we have collected sufficient evidence to prove gross negligence as the standard is contained in the statute. They have defended the case as though we are asserting gross negligence, to the point where they filed a motion for summary judgment indicating we haven't proven no gross negligence. They have defended the case on a gross negligence standard. I think that it's inaccurate that they have been prejudiced that we did not include one word in our complaint, gross, and that they would have had a different procedure or a different involvement in the case that they now have not been able to get by us not including gross. I'd also like to circle back around and address the $270 in my last couple of seconds. We can't use the breakdown that they are promoting. The facts are clear. Jared Allen himself paid the $270. He paid this all. He did not only pay $2.81. It would be a disservice to the facts. It would be a disservice to the court to accept that he only paid $2.81 because he paid $270.
Why does that take it out of the nominal fee? If I agree to pay for 500 of my friends to go to a national park and it's $1 admission fee, and that 50-cent admission fee that everybody agrees is a nominal amount, but the fact that I agreed to pay for 500 other people, I've now paid $500, which doesn't seem very nominal, but why doesn't your client have the ability to collect that from, just like I could collect from my 500 friends? The fee is what's charged per person to use the facility.
And that's what a jury needs to decide. The court should not be deciding whether or not he was wealthy enough to pay the $270, therefore it's not nominal, or it is nominal.
Is there any question that he could collect a pro rata share from everybody who played on the softball team?
I'm sorry?
Is there any question that he would not be able to collect the pro rata share of the admission fee?
He could have, but he didn't. In this specific case, he did not. And we have to take this nominal on a case-by-case status. It is not an objective standard. It's a subjective standard. It's case-specific. It's fact-specific, as the McKinney court indicated. And there should be
that would put a burden on the city or whoever owns the property to say nominal. They would have no way of ever knowing if it's nominal if they don't know whether somebody's going to pay on behalf of others.
If the court found that $270 was nominal, then that is going to provide immunity for all of Parks and Rec softball fields all over the state of Arizona. That's the average amount that teams pay to play in an organized effort, to come to a field that's reserved for them, to have lights, to have umpires, to have bases out there. And if $270 is considered nominal under Title 33, 1551, that's just going to provide qualified immunity across the board. It needs to be on a case-by-case scenario. In this case, there's additional facts that the defense could collect and promote at trial and ask the jury to find that this was a nominal fee. It's a question of fact for the jury.
Okay.
My time is up. Thank you very much.
Thank you. Thank you to both sets of lawyers for your briefing and your argument. We'll take the matter under advisement and issue a decision in due course. Now we will adjourn.